All right, so let's begin here. Now, for constitutional supremacy and parliamentary sovereignty, right? Before I go through the information that is already presented here, I want somebody to discuss for me, right? What does constitutional supremacy talk about? What does it mean? What does it bring to mind? Go ahead.
Sir, basically the Constitution standing supreme over all institutions, citizens, and government.
So over all institutions, citizens, and government. All right. So could somebody add to that? What does the term refer to?
The Constitution being the supreme law of the land.
All right, so the Constitution being the supreme law of the land, Constitution is the highest law of any, well, of an independent country, as I would state. All right, and we're speaking about the fact that it is so-called supreme because any laws passed by the country's parliament, right, that conflicts with the Constitution would be said to be unconstitutional and therefore null and void. So we're looking at the fact that the Constitution itself, right, is supreme over all others. Go ahead.
Sir, so I was saying basically the constitutional supremacy it makes parliament subordinate to the constitution. So like that's why the constitution is the highest source of law, and it is like all laws derive from the constitution. So anything the constitution basically, for instance, wait, what can I use? I don't know, sir, but it's just that anything them say goes.
Right, so anything the Constitution says goes. All right. So for Commonwealth Caribbean countries, we know that we have a written constitution, and in our countries per se, we have a little bit more supremacy of the constitution more so than parliamentary sovereignty. All right, within jurisdictions where there is an unwritten constitution, right, where the constitution is learned through oral tradition, right, there is a little bit more edge to parliamentary sovereignty. We're going to be discussing that. What would parliamentary sovereignty be speaking about, though?
Like, for instance, in the UK, Parliament is supreme. That is where they turn to Parliament being able to make laws and so forth in the UK.
Okay, so we're speaking about the concept, right? So we're looking at Okay, go ahead. I see there is a hand. Go ahead.
Okay, sir. So I was saying, sir, we could talk about dicey right here, where it talks about the parliamentary, the parliamentary. Wait, is it the supremacy? Is it the same thing, sir? Supremacy and sovereignty, or no?
Um, Technically, okay. Well, there are differences between it, right? Because we're saying that the Constitution is supreme over all laws in the land, right? As the supremacy rule, that concept that is the highest thing, right? But sovereignty speaks to the fact that the power, right, is vested in the parliament, right, to actually be able to change these laws and, in case, change the constitution. So looking at the sovereign power of the parliament itself to actually override these laws.
Okay, sir.
Right? So we're looking at that, because there's a challenge between them, right? You have constitutional supremists, right? And you have the parliamentary supremists. Persons who believe that the constitution should completely be supreme over all parliamentary rulings, and some persons that look at it from a parliamentary standpoint, saying that even though the constitution is supreme, right, the parliament does have procedures that can change the constitution. So isn't the parliament supreme? We're speaking about these issues, right? So it's really the conflicts we're looking at there, looking at what these two terms mean, right? And the entire parliamentary sovereignty, where it comes from, right, historically, right, is the Enlightenment period, right? we can look at the Enlightenment period specifically, right? And the fact that there was a divine right to rule, right, specifically with throughout European monarchies, etc., right? And after what we'd call the Golden Revolution in Britain, right? And the change of dynasty, right? What was happening in Britain at the time, the different wars that were fought, right? At the end of those issues within Britain, it was decided that the Parliament was to be supreme, right? And the Parliament had sole sovereign, well, made majority of the sovereign right to determine the path of a country, right? So we're looking at parliamentary sovereignty there, and looking at the fact that the Parliament itself will create all these different acts and ordinances, right, and ameliorations to the Constitution itself. So some persons are looking. Well, that is our standpoint, right? When we look at parliamentary sovereignty, right? So we're looking at the supremacy of the Parliament, right, through parliamentary sovereignty. Okay. So the supremacy of the Constitution, we discussed that already. We're looking at the fact that it is the highest legal authority within the entire jurisdiction. It sets out the structure of government, it sets out the branches of government, all fundamental rights and freedoms of all citizens, right? And all procedures. So what does this mean? When there's an abuse of legal authority, right, it contradicts the Constitution, right? When there's no delineation of separation of powers, it contradicts the Constitution. When there's a breach of fundamental rights and freedoms, it contradicts the Constitution. When we're looking at the incorrect procedures being used, procedural ultra vires, we have the conflict to the Constitution. And we're stating through constitutional supremacy that if there are any conflicts within these different things that are stipulated by the Constitution, it is seen as unconstitutional and completely null and void. Right? And any law itself that was passed by Parliament that conflicts with the Constitution is no law at all because it conflicts with the Constitution. So looking at that, right? So if there's any fight between the Constitution and anything else, the Constitution will always win. Right? That's what the thing is really speaking about, right? And what parliamentary sovereignty really speaks about, right? Specifically within parliamentary democracies, right? Most Caribbean countries are not democracies; they are monarchies. But in parliamentary democracies, most likely you'll see that the parliament itself, the legislative body, is seen as supreme and sovereign, right? Because they have the legal authority, the ultimate authority is vested in them to repeal any laws, right? Specifically, right, to make and repeal laws as they see fit, right? No other institution, the judicature, the executive, have no power to do this but the legislation. So we're saying that the parliament has their own sovereignty, right? So it implies specifically that the parliament is not bounded, right, by anything, by any previous legislative decision, right? And they can enact, amend, and repeal any law it chooses, right? So we're looking at that, the power of the parliament specifically, right? So even though the Constitution is there, right, the Parliament can change the Constitution as they see fit, as long as they follow the procedures, the voting procedures, the majority vote, and those type of stuff, right? As long as they pass those things, they can change any law, right? As long as they fulfill those procedures, right, and the requirements to change the laws. So that's what parliamentary sovereignty speaks about. So which is truly supreme? The Constitution or the Parliament that can change the Constitution? Interesting. Within the Commonwealth Caribbean countries, it is usually constitutional supremacy is the thing that we gravitate to most because it's a written constitution. Our constitutions are the acts of Parliament made by our metropoles and given to us as given law, right? In order to change the laws entrenched in the constitution, right, via Parliament, it's going to be very, very difficult, right? It's gonna be most definitely extremely difficult. Along with the fact that a good amount of the things within our constitutions, right, are entrenched from the Declaration of Delhi and from the Bill of Rights and those type of things that are also a part of international law, which can't just be repealed like that. Right? So we're looking at the fact that there's some conflict between whether or not the Parliament has complete and sole sovereign power over the jurisdiction, right, that they have, right, or if do they have to bow down to the Constitution? We're looking at those things, right? So we're discussing constitutional supremacy and parliamentary sovereignty, and we must look at the conflicts between them, right? The judicial review and legislative authority, right? We know that the legislature has the power to pass laws, right? They have the power to pass the laws themselves, right? Repeal laws as they see fit, as long as they go through the specific procedures, right? But the judicature itself has the power, right, to review these decisions made by legislation, made by administrative boards, or any legal authority. Well, not any legal, any public authority, right? We're looking at the fact that we have judicial review, right? So even though the Parliament itself has the sovereign power to change, make, enact any law that they wish, as long as it goes through the right procedures, the judicature has a duty to protect the Constitution, right? Once they find a law that contradicts the Constitution, the Supreme Court of the land can tell Parliament that this is not going to work, that this law is null and void. The judicature are the complete defenders of the Constitution via the procedure of judicial review, and that is something that we'll discuss in the topic specifically dealing with judicial review, right? So parliamentarians believe that they have the sole authority to make laws without interference from the judicature, right? Because that is understandable, that is in separation of powers. But the checks and balance system from the separation of powers must also be taken into consideration, right? So the parliamentarians that we have within our nations, yes, they have the power to go to Parliament, to talk their big arguments and pass their laws, right? And the executive, if the executive wish, the executive will review the laws and pass them completely, right? But as long as these laws contradict with the Constitution, none shall pass the judicature, as they are the supreme defenders of the Constitution. As long as it is seen as unconstitutional, the judicature declares it as null and void. It will not be upheld. Alright? Make sense? Alright. The protection of fundamental rights. So we know that due to the fundamental rights and freedoms actually cause some a conflict between constitutional supremacy and parliamentary sovereignty, right? There may be instances in which Parliament may enact laws that infringe upon these rights, right? And the judicature will intervene, right, to strike down any such laws asserting supremacy over the Constitution, right? So anything, any law that contradicts, especially when it comes to the protection of fundamental rights and freedoms, will be struck down, right? And it will assert the supremacy of the Constitution over the parliamentary actions, right? So look at stuff like that. This is what the world ought to be. We're looking at law as it ought to be, not what it is. Please keep that in mind, right? So our fundamental rights and freedoms, we'll look at them when we start talking about the fundamental rights and freedoms, right? The freedom to self-determination, the freedom of speech, freedom of this, the freedom of that, the freedom of the right to choose and to choose any sexual orientation. All of these different types of rights, right, are defended and enshrined within the constitution of our countries, and laws must not contradict these, right? So we could speak about how our society may be, right, and the different things in which our society may enact, right? But the Parliament cannot pass laws to support anything that contradicts the rights of citizens because it is enshrined within the Constitution, right? So we're looking at that. All right. We also have amendment procedures. Even though the Parliament does have the power within themselves to make amendments to the Constitution itself outlines the procedures for amending their provisions, right? So that's another thing as well. So even though the parliament, right, the parliament can seek to amend the constitution in a um in a manner that undermines its fundamental principles or alters the balance of power between the branches of government, right? We can look at that. The parliament does have the power to change the constitution, and the constitution outlines the procedures for parliament changing these provisions, right? And this will cause a huge issue, right? So is there really parliamentary sovereignty over constitutional supremacy here? Kind of, right? What we're going to see is debate on the legitimacy of parliament, right, and its actions, because parliament can ultimately change the constitution, right? Because if they pass a law that is unconstitutional and they amend the constitution to make the law no constitutional, doesn't that mean that parliament has supreme sovereign power over the constitution? If you think about it, yes it does. So that will trigger complete debates whether or not the constitution is truly the highest law in the land, or is it parliament? Would think about those things. Those are the main. Go ahead. What do you think? Go ahead.
So, sir, is it like the constitutional supremacy and the parliamentary sovereignty is in like a competition about which laws should be in a specific place or something like that?
Okay, so they're in conflict. The two terms are in conflict, right? Two concepts. Is it about which laws should be in place? Not necessarily about which laws should be in place, but which one is higher, right? Which one is more supreme over the other, right? It's really an argument like that. Go ahead.
Sir, I feel like the Constitution is supreme simply
Mm.
because if Parliament passes a law and it has to be amended to fit the Constitution, isn't the Constitution still supreme because they have to amend their law to fit what the Constitution wants?
Lovely. That is true. So that shows constitutional supremacy. Go ahead,
Yeah.
Shada.
And also, I agree that the Constitution is supreme because in the case of Collingwood versus the Attorney General, the
Mm-hmm.
court ruled that no one, not even Parliament, can disobey the Constitution with impunity.
Lovely. So looking at that, that's law. That's case law specifically to the supremacy of the Constitution. Lovely. Go ahead. Go ahead.
Sir, and in addition to what Toya and Jada said, sir, if Parliament cannot pass any laws that are not in line with the Constitution, and the judiciary is there to make sure that Parliament does not pass any law that are not in line with the Constitution, then automatically the Constitution is supreme. Sir,
Okay.
that's my point of view.
Lovely. All right. So I love those standpoints. So we're all agreeing that the Constitution is ultimately, whether or not we have discourses between each, right? We're looking at that the fact that constitutional supremacy supersedes parliamentary sovereignty. That's what we're saying. That seems like the main consensus. Even though the parliament could technically change the constitution to do whatever they want, they still have to be bounded by the principles and procedures in the constitution. And even though I'm not saying that parliament can change the entire constitution, no, that will that cannot happen because some of the things in the constitution are bounded by international law, and we'll discuss those, right? Federalism and regional autonomy. These things are for federal systems and different governments, right? Um that really creates conflict between central parliament and regional state governments, right? And over the divisions of power. Parliamentary supremacy may protect the autonomy of regional governments, while parliamentary sovereignty may lead to the central parliament, right, to assert its authority over, right, matters traditionally within the purview of regional governments, right? So some countries will have these issues, right? So we could think about the United States for an example, right? The United States Constitution, right, is going to be delineated and protected by the Supreme Court, right? And the matters are discussed by Congress. But each individual state has their own specific court system and has their own specific legislature, right? So there are conflicts between the supremacy of the constitution that governs all the states, right? As well as there's conflict with the legislature in individual states to make their own laws. But this is a subsidiary argument here because within the Commonwealth Caribbean, we don't technically have federal states, right? But it's another conflict that I was willing to share. So the case law, we're looking at case law that supports the supremacy of the Constitution. Collymore versus the Attorney General. Go ahead. Anyone? What is the case law? What are the facts? And what did the Chief Justice Wooding say? And what did Fraser say? Go ahead. This is a very important case for this, you know. If you don't know, the Heinz VR and Collymore v. Attorney General and don't know what we've been doing throughout the entire semester. But let's go. Somebody just give me the case for Collymore v. Attorney General.
Sir, in this case, Collymore versus Attorney General is a case of the Privy Council relevant for UK labour law concerning the right to strike. So Collymore and other trade union members of the oil companies claim that a new Industrial Stabilization Act of 1965 in Trinidad and Tobago was ultra-vires to the Constitution, was beyond the Constitution, which guaranteed their freedom of association. So the act required no strikes pending binding arbitration. And the Privy Council advised that the act did not breach the Constitution. However, the court ruled that also in that case that no one, not even Parliament, can disobey the Constitution with impunity.
Okay, lovely. So what did the Chief Justice Wooding, right, in his consideration of Section 36 of the Trinidad and Tobago Constitution, he said that Parliament may make laws for peace and order and good government of Trinidad and Tobago. And he also stated, right, that in his judgment, right, so he's stating here verbatim, in my judgment, the section means what it says. And what it says, and says very clearly, right, is that the power and the authority of Parliament to make laws are subject to the Constitution's provisions. The Parliament may therefore be sovereign within the limits thereby set, but if and whether it should seek to make any law, such as the Constitution forbids, it will be committing an act of ultra vires, right? So even though the Parliament is supreme and not supreme but sovereign, right? They have the sovereign power to make this law and pass the Industrial Stabilization Act of 1965, right? All laws must be subject to that of the Constitution, right? So we're looking at those type of things. His lordship, among other things, inter alia, which means among other things, right? So that the Supreme Court is the guardian of the Constitution, therefore, in its competence, and it was its right and duty to declare binding declarations, right? And declarations are actually a type of remedy of judicial review, which we will speak about, right? So we're looking at also Fraser J.A. in the same case, right? The obiter dictum presented by his lordship, right? No question of sovereignty of Parliament arises. Parliament can amend the Constitution only if the Constitution prescriptions are observed, and providing Parliament fulfills the requirements of the Constitution, its power is sovereign and supreme. So this case supports the fact that no law can be changed that disregards the Constitution. No Parliament can disregard the Constitution without impunity, right? We are looking at these things. So Collymore versus the Attorney General of Trinidad and Tobago, right, is the earliest regional authority on this case. This is where these readings of constitutional supremacy are handed down from, and you must. Did I say maybe? Did I say probably? You must know the case, right? So we have to know this case. We also have bribery commissioners versus Rana Singh of 1965, right? And we also have Heinz VR 1977. Heinz VR is a case that was decided, right, after Collymore. Right, so it's after Collymore. Right, so we're looking at what's happening within Hines v. R. Could somebody please reinstate the case facts for Hines versus the Queen?
Sir,
Go ahead.
so is this a case where like the Parliament of Jamaica, like they came about with a new court, which is the gun court, right?
Mm-hmm.
To basically talk about some firearms offences, right?
Mm-hmm.
Is it this one?
Yes, it's that one.
Okay,
So,
sir, go ahead.
okay. So Hines VR 1977, we have the provisions under the Gun Court Act of 1974, right? So basically, let me just skip all of the main facts and just speak about the essence of the case, right? So essentially, right, there there was there were five appellants, right, that were convicted by a registered magistrate under the division of the Gun Court, right, due to unlawful possession of firearms and ammunition, those type of things, right? They were sentenced to detention and hard labor, right, during the Governor General's pleasure, acting as an advice to the review board. No. There were several members on the review board under the gun court, right? Listening, right? Only two, I think it's around 2 or 3 of them, were members of the Judicial, right? Then you had other members, and then you had the attorney, not the attorney general, the governor general. The governor general, within the pleasure of the governor general, these persons were sentenced to hard labor, right? To detention and hard labor. What is the issue there? What's the issue there?
Sir, as it relates to separation of power, is basically people that aren't a part. So, sir, I don't know how to explain it, but people coming together that are not a part of that jurisdiction or something like that.
Okay. So we're seeing the provisions under relevant sections of in 1974, right? The Act, the Gun Court Act, right? That an executive body was put together to exercise complete discretion of what should be actually dealt with under the judicature, right? The judiciary, right, has the power to send to actually try and sentence. What occurred here is an executive body was doing the job of the judiciary, right? They had complete discretion to determine the severity of punishment to be inflicted on the offenders. No, as big bananas bold as governor generals are, they are not members of the judiciary. Therefore, they do not have power, right? Whatever they want to say, they do not have power to do this, right? So we had this issue within 1974, right? Where an executive board exercised powers that are supposed to be exercised by the judiciary. Substantive ultra virus, right? We have an issue here, right? So we're looking at this, it's substantive and somewhat procedural as well, right? So we're looking at the fact that an executive body was exercising the right of the judiciary, breaching the doctrine of separation of powers, right? We're looking at that. So this was in conflict with the Constitution. We had judicial review taking this over. So there had to be the judicial review by the courts in Jamaica that would take over this entire thing. So it was appealed eventually by the Privy Council, contending that all the provisions in 1974, this 1974 Act, related to the sentences were unconstitutional. Because we cannot have an executive board deciding things that should be decided by the judiciary. Cannot happen. Alright? So that was generally this. So the entire act, the sections under the act were deemed null and void because they contradicted the Constitution. Right? And this assists in our understanding that constitutional supremacy in Commonwealth Caribbean states is higher than that of parliamentary sovereignty, right? In Commonwealth Caribbean states. So we have those cases there. Entrenchment now. We know what entrenchment means. Entrenchment in the context of the Constitution refers to the process by making certain provisions or elements of the Constitution more difficult to amend right, or repeal than others. So essentially, it's a mechanism designed to safeguard the fundamental principles. So fundamental principles, rights, are structures within the Constitution from easy modification by ordinary legislative processes, right? So when you have things that are entrenched, Parliament can't get up, and the entire Parliament vote yes, and that's it. No, 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 right? Some of these things, right, are entrenched in the Constitution and are not easily repealed or amended, right? So some of these things need complete all island referendums and those type of things in order to change, right? The society itself must agree. Parliament can't just get up one day and say, I think that we should repeal the right to speak. They can't just get up and do that, right? So we're looking at that. So these things are entrenched, right? So there must be a supermajority required, right, for entrenchment, right? So that's the most common method, right? A supermajority of the legislature, right, to amend certain parts of the constitution, and this means that larger portion of lawmakers must support the amendment, right? Then there's a referendum requirement, right, in which a referendum must be held, right? A referendum of the electorate in addition to being passed by the legislature, right? So the electorate must go through the referendum, meaning the people, the voters must go through that entire referendum, and then that is being in addition to being passed by the legislature by a supermajority, right? And then there's special amendment procedures that must be gone through, right? There are special procedures or requirements specifically for amending entrenchment provisions, right? This could include conditions such as multiple readings of the amendment bills, public hearings, and approval by specific government bodies, right? And then there's unamendable clauses. So in rare cases, constitutions may contain clauses that are explicitly declared unamendable, right? So the constitution say, hey, this right here, no parliamentary procedure can change this, right? So some constitutions have unamendable clauses, right? These clauses typically protect the core principles such as the form of government in which we have in the jurisdiction, the territorial integrity, and fundamental rights and freedoms. Some of these clauses cannot be changed no matter how hard Parliament say. The entire country could have voted yes, but it's not going to change, right? So we're looking at those type of things. So entrenchment is really important for making it difficult, right, for things in the constitution to be just completely changed on a whim. Everybody's fine so far? All right. So the second case is here. So Heinz v. Arno would have noticeable entrenchment, right? Because the reason why Heinz v. R, that case went the way it did is because of the sections of the Gun Court Act contradicted the specific things that were entrenched in the Constitution. The separation of powers and the structure of government, which generally is either extremely hard to amend or unamendable. So that would have been an issue there for Heinz v. R. We also have the Independent Jamaica Council for Human Rights versus Marshall Burnett, 2005, right? So that was an issue with the that was a general issue here, right? So we're looking at that. The Jamaica Parliament enacted legislation to amend the Constitution of Jamaica to replace the Privy Council as the final court of appeal in Jamaica. So they tried to replace the Privy Council, right, in favor of the CCJ, right? What occurred after? Anybody can give me the rest of the facts? What were the issues? Okay, let me just go through the issues, right? The issues here, right, was that when Jamaica tried to change the Privy Council for the CCJ, right, that would have affected the security and tenure and independence of the judiciary, right, because that will now change, right, the entire process within Jamaica, right, as Jamaica's final court of appeal was the Privy Council, and that was entrenched. You can't just change it like that, right? It was entrenched. Can't be changed so easily, right? We also look at the contrast specifically, right? Where we look at the fact that there was nothing entrenching the appointment of judges to the Caribbean Court of Justice, the Jamaican Constitution explicitly denies this change, right? Well, I wouldn't say explicitly, but these provisions under the Jamaican Constitution denies the Jamaican Parliament from changing the Privy Council for the CCJ. And because these things are entrenched, that's why referendums and special procedures must be made within the structure of Jamaica itself, within the electorate of Jamaica, in order for there to be a change from the Privy Council to the CCJ. Because you cannot just go against the constitution like that. The newly passed legislation that will change the Privy Council for CCJ was unconstitutional, and it undermined the protection of people in Jamaica by the entrenched provisions in the constitution. Right? We're looking at that. It was going to affect the independence of the judiciary, right? As well as it was completely unconstitutional to allow these issues to arise. Alright? So we're looking at that. So that's generally there. So that's our discussion on the constitutional supremacy and parliamentary sovereignty. Alright? Hopefully everything there is fine.